Hey guys, attorney Jerry Parisi here, and today I'm going to answer the question, what happens when you're sued for debt in Georgia? And I'm really specifically talking about magistrate here in this video, magistrate court cases. So I'm not talking about state court or superior court. I'm talking about the lower level of court, which has a jurisdictional limit up to $15,000. It's sometimes called or referred to as small claims court, but it's really magistrate court. And that's all I'm talking about, so specific to that in this video. And it's just a general, this is probably what's going to happen. Your case may differ slightly, but this is a general overview of what to expect when you're sued for debt in Georgia. So we're going to talk about a couple things, what happens, what gets filed, what happens after it's filed, how is service perfected, what the court does after service is perfected, and then the trial date and what to expect for that. So jump right into it. The first thing that happens is the plaintiff will have their attorneys file what's called a statement of claim in the magistrate court. The statement of claim is, all it has to be is just a general, really short statement of what the plaintiff's claims are. So statement on claim on an account, like you had an account and you failed to pay it, or a breach of contract, like you had a credit card agreement, you defaulted on it, stuff like that. So just a really short sentence or two to put you on notice of what their lawsuit is all about. They could also attach to the statement of claim, which you'll sometimes see, they'll say, see the attached complaint. And the complaint will set out more factual allegations and their theory of recovery, what they think the law that should apply is. And then they can also attach their evidence to the lawsuit. So account statements, medical bills, hospital bills, things like that can be attached as well. Sometimes they'll have business records affidavits attached, sometimes they won't. And so that'll all get filed, and then it'll be sent out for service. It can be sent out with either the sheriff's deputy or by a private process server. And what they'll do is they'll try to find you and serve you personally. So there's two ways they can serve you, personally or by notorious service. The first, they're going to try to find you personally because that's a better form of service. They're going to try to hand you a packet that contains the summons and the complaint or the statement of claim and maybe their evidence. And they're going to say, here, Mr. Jones, here, Mrs. Jones, you've been served. And that starts the clock ticking. Another way to serve you is by notorious service. And what notorious service is they can't find you, but they go to your house, your apartment, wherever you live, and here's what the law says they can do. So they can leave copies at your dwelling house or usual place of abode with someone of suitable age and discretion, then residing therein. So a lot to unpack there, but basically what it means is they go to wherever you live, wherever you reside, and leave it with somebody of suitable age and discretion. And Georgia courts have found that people 12 and 13 years old are old enough to accept service on your behalf. So they don't have to be 18, so don't bring up that argument. But the person has to be living there. It can't be your cousin who's sleeping on your couch for a week. It can't be your cleaning lady who's at the house when you're at work. It has to be somebody who lives there and is of suitable age and discretion. So your kids, your parents, your spouse, whoever lives at your house and is old enough. Once that service has been perfected, or once the plaintiff goes back and tells the court that service has been perfected, that starts the clock ticking. That gives the court jurisdiction over you, and it starts the clock ticking, like I said. So you've got 30 days from service to file an answer to the lawsuit, or else you could be in default. So 30 days, you need to file your answer with the court, get that in there, or you'll be in default. So we're not going to talk about default. That's a different video topic. But after you file the answer, generally what's going to happen is one of two things. Either the court will mandate that you go to mediation, so they'll require that you attend mediation. Not every county does this, right? So Fulton County will require mediation. You'll go down to the Fulton County Justice Center and you'll mediate the case. They'll set a date and you'll go to mediation. You'll sit down with the attorney for the plaintiff and you'll try to come up with a settlement agreement. You don't have to settle anything. but the court wants to give you a chance to because their dockets are full of these cases, and it just helps them weed them out if people can come to a settlement beforehand. But not every county, not every court will require mediation prior to your court date. So they could just schedule a trial date for you. And these trial dates are going to be pretty quick after you've been served, right? It's going to be like a month or two. They're not going to wait around. Magistrate court moves pretty quickly, right? And they got full dockets, so they crank these cases through. So you'll get scheduled for a trial date, and you want to make sure you attend that trial date. If for some reason you've got a conflict, and you're representing yourself, say you don't have an attorney, you want to call the clerk, call the judge's chambers, get somebody on the phone and say, hey, I can't make that court date. What do I do? You want to get that moved if you really, there's no way you can attend. If you don't have something like that, or if the court doesn't give you a new trial date, you have to attend. Don't forget to attend, or else you'll be in default. So attend court, and then what happens on your trial date. So make sure you get there on time, guys. I can't stress this enough. I've been in court. I've seen, where people are late and the judge will not allow them to have their day in court, right? So you want to get there. The first thing that's going to happen is the judge is going to come on the bench at whatever time your hearing is, and they're going to read some general guidelines about how the day is going to go, what they're going to do. They're going to give you a little bit about the law, maybe, and they're going to then call the calendar. So they're going to have a list of all the cases that are scheduled for a trial that day, and they're going to go through one by one and call and make sure everybody's here for both the plaintiff and the defendant. And when they call your name, you want to stand up and say, yes, Your Honor, I'm here, I'm present, and I'm ready to go. So don't be quiet, don't sit down and let the judge miss you. And you want to make sure you're there at the calendar call. You don't want to be late for that. So what will happen after that is the judge will give you guys instructions. He or she will usually release you to talk to the other side. So sometimes at court there will be an option for to have mediation there, and mediation is you and the plaintiff sitting down with a third-party neutral called a mediator, and they'll try to help you guys work something out, work out a payment plan, work out a lump sum settlement agreement, whatever, or mutual dismissal, however your case shakes out. If you guys can't come to an agreement, sometimes you can continue to negotiate out in the hallway. If the court in your jurisdiction doesn't have a mediator for whatever reason, you can go out in the hallway and just discuss with the plaintiff's attorney, try to work out an agreement. You can work out like a settlement, like I said, with the lump sum or the payment plans, or even best case scenario, dismissal. It just depends on the facts of your case and what you guys can work out. If you can't come to an agreement, you're going to go back into the courtroom and wait until your case is called. The judge is going to go through the cases. She's going to ask you, have you come to an agreement? If you have come to an agreement, the plaintiff's attorney is probably going to draw it up on a piece of paper. You sign it, make sure it's how you want it, make sure it's what you agree to, and it's going to be presented to the judge. The judge is going to sign it and enter it as an order, and it's binding with the court. If you guys don't come to a settlement agreement, your case is going to be set for a hearing, and then the judge is going to go through all the cases of the day that haven't settled, and they're going to have trials. These are going to be really, it's not like Law and Order, what you see on TV. It's going to be really short, brief, quick trials. Get straight to it. The plaintiff is going to go first and present their evidence, call witnesses if they have them, enter documents if they can, and then you're going to get to cross-examine witnesses if they've got them, or talk about their documents, and then the plaintiff will rest their case, and then you'll get up and get a chance to present your case, whatever your defenses are. You can call witnesses if you got them, enter documents if the court will allow it, and then closing arguments really quick, and then the judge will either take it under advisement and then submit her judgment later, or she'll rule on it there. Usually, in my opinion, they usually take it under advisement and won't give you an order there, but you'll get it later. If you lose, great thing in magistrate court is you get 30 days to appeal it. You get a brand new trial if you appeal it. All you got to do is pay the court costs to the appealing court, the appellate court, which you'll either appeal it to state or Superior Court, and you'll get a brand new trial. So if you go to Magistrate Court, you lose your case, all you got to do is pay whatever, a few $100, get a whole new trial, and that's your right, and then start over. So then you could enter into a settlement agreement if you want, or you could go fight it at state court or Superior Court. But that's generally how the magistrate court process works in Georgia. Really quick, brief overview. There's a lot more stuff to it, and it just really depends on your case and your facts, who the attorney is on the other side. But all throughout this process, guys, after the lawsuit's been filed, up until the moment you walk into trial, anytime in there, you can negotiate a settlement with the plaintiff. Like I said, out in the hallway, or even before your trial date over the phone, call them up and, get that thing settled so you don't have to show up in court and potentially lose and be subject to a judgment against you for the full amount. Try to settle it for a lower amount. That's what I do all the time. That's what I do every day. If you need an attorney's help, and I definitely suggest that you hire an attorney if you can afford it. If you can't afford it, try legal aid. But definitely reach out to an attorney, get a consultation, see what your options are. Like I said, I handle these cases every day. We settle them. Sometimes we fight them if we can. But sometimes if we've got great facts on our side, if we've got counterclaims and defenses, sometimes, the plaintiff will often just agree to a mutual dismissal. Both sides walk away. And that's oftentimes best case scenario. So give me a call if you have any questions, guys. 404-594-5130. Brief overview on the magistrate court process in Georgia. Thanks.